continuing testimony on S4. We're next going to take a look at some proposed additional language, and we're joined by the Honorable Representative Harrison to tell us what this one's all about.
Good morning. Representative Jim Harrison from Rutland 11, and I'm here to share with you a potential amendment to S4 for your consideration. Just give you a little bit of background why I'm offering it. Unfortunately, as we all witness, there's perhaps an increasing lack of civility at local meetings with some individuals in some towns. Today, under state statute, we ban firearms in schools. If it was last year or 2 years ago, we banned firearms in hospitals. And it is unclear to me whether the law allows governing bodies like your select board to ban them in town-owned buildings. If you look at Title 24, Section 2291, it says that this is under municipal authority. It says they can regulate or prohibit the use or discharge, but not possession of firearms within the municipality. 2295 goes on to say no town, city, or incorporated village by ordinance, resolution, or other enactment shall directly regulate hunting, fishing, trapping, possession, ownership, transportation, transfer, sale, purchase, carrying, licensing, or registration of traps, firearms, ammunition, etc. I believe some municipalities may have such authority under a provision in their charters. I haven't looked through them all, but it's possible that some do have that authority. I'm not positive of that. VLCT, the League of Cities and Towns, could not refer me to any towns that currently ban firearms in their town offices. And they have been, I believe, operating under the assumption that it is not allowed under Vermont law because of the Title 24 language that I just referred to. So this amendment, and I don't know, have you got it up on your screen?
I think we all have a copy of it.
Yeah. Basically, very simple, and it makes it clear that a municipality shall have the authority to adopt a resolution that designates municipally owned buildings or a portion of those buildings as firearm free. Furthermore, in one of our district towns, the town office is now had to resort to being open only by appointment, which is really unfair to townspeople. If you go to the Town of Mendon website, it says office closure by appointment, and it goes on to say in their statement, the town is frequently encountered person/pearl coming into the office that are very disrupted with tirades, sometimes lasting as long as 30 to 45 minutes, and occasionally coming into the office twice in the same day. These person, plural, involved are using profanity, yelling, making false accusations, and derogatory remarks against office staff and community members. Then it goes on further to say that it's now open only by appointment. The town has had one select board member resign last fall. They've had a zoning administrator resign. And this amendment does not fix those issues, but it might give, sticks and stones will break my bones, but words will never hurt me. I'm not sure that that's entirely accurate in this case, but being called names is better than having someone potentially lose it and pull a firearm on you. So that's what the amendment does. And also some conversations I've had with other interested parties. I have asked Ledge Council this morning to draft a second amendment that I believe will do the same thing for your consideration. And that would be under Title 13, Section 3705, which is unlawful trespass.
So same exact language, but
Yeah, I believe so. I should have it early this afternoon. As you know, this time of year, Ledge Council is multitasking, and I don't have a preference one way or another. I do know there's a sensitivity to putting something in Title 24. If the same thing can be done in Title, what did I say, 13?
13.
Yeah, I'm totally fine with that as well. So that's essentially my story, and ask for your consideration on this permissive authority, which some believe is allowed now, but unfortunately, it's not specific, and certainly in reading the existing statute, you could be led to believe it's not, and there's been no court cases that I'm aware of that have clarified it.
Ken, Tom, did you?
So Jim, I can understand this. We went through the same situation with a very disgruntled and still very upset person in Northfield that threatened all of us on the select board, even shooting us and then threatening the employees and all that stuff. And I think we put the signs up, and I think we had law enforcement in many times, but I thought we went one step further that kept him out of there. I thought there was some law, I could be wrong, that needs to be looked into, but I share your concerns on this. We were fortunate to have it dissolve a little bit, but you never know when the next one's coming up. Although on the other side of the coin, I don't know how to.
Yeah, and this is not a perfect answer at all, and may not solve the issue. I know the town select board has had conversations with their town attorney to find out what options might be available to them. I'm not privy to those conversations. You know, we have a very constitutional right to free speech.
Yeah.
And because you use profanity and are disruptive, especially because this is a town building, I don't know where those constitutional rights, adhere to, count, don't count. So that's something they, certainly are looking at it. But in fairness to the town employees, no one should be subject to that type of work environment, and the town select board is trying to alleviate some of that, which fortunately has meant going to appointment.
This, the same individual came right to the field outside of my house and said he had a gun right on me and was going to pull the trigger. So.
That would be some other offenses that can trigger there.
I told him to do it, and he just went click and hung up. So I'm still here.
So we're glad you're here.
I'm just curious, have you called law enforcement yet? Or did you like not to for any particular reason in your conversations?
So the town has, and my limited understanding is that, the person has been kind of walking that fine line up to actually threatening. Swearing and talking out of turn is not necessarily threatening. I remember a conversation with the former select board chair who pushed the panic button at one of their select board meetings, and the state police came and basically told them, no, you cannot call us in a panic because someone is being obnoxious at a select board meeting. So I don't know that this fixes the issue. There's an article, and I'm happy to give you the site for it, recently in the Rutland Herald, where the individual in question had a some misdemeanor charges dismissed and wouldn't see jail time if he had complied with the court orders. One of the court orders was doing anger management class. I don't know if the person has done that yet or whether that will fix it. It's a very, very difficult situation, and I'm just trying to give options to the town.
Tom, this question.
Say if we pass this, I mean, everybody knows that if somebody's going to break a law and decide to shoot somebody, they're going to do it, regardless if we had this amendment or not.
Well, it's against the law now to shoot somebody
Well,
in most cases.
Exactly.
Yeah.
So say if we pass this amendment, would this stop a select board member from potentially protecting themselves with a firearm?
I'm not a lawyer. I would assume it would unless they're law enforcement. And
A select board member or a employee?
The current select board is 3 women. I don't know that any of them carry firearms, to be honest with you. I don't believe the town clerk or assistant town clerk do. It's a small town.
Not to be nitpicky, probably not a gender issue.
It's probably not. I'm just sharing the makeup of the select board.
It certainly looks to me like they could be in violation of disorderly conduct.
Well, and again, I'm not privy to the conversations with their town attorney. Perhaps that's being looked at as well. But I'm just trying to put options, and it's not just this town, any town, and unfortunately see that. And again, it may not help the issue at all, but I don't know why we wouldn't. Private business can do this, but because it's town-owned, they may or may not be able to do that. I'm just, if the store down the street from a town office can choose to post their property, and I don't know why we would not allow the town office to do the same thing.
So probably the language needs a little work, because if it's firearms free, does that restrict the municipality from being able to say that law enforcement can have firearms? So it may be language, if we proceed with this, that allows the municipality to place restrictions on firearms within, because then that gives them a little more leeway to authorize security or whatever to have.
Sure.
But we can work with Tucker on that.
Yeah.
I'm sorry that Tucker's not here to walk us through on that today, but I have emailed him to see if he has some availability either later today or tomorrow when we take this back up, so we can ask him questions.
Yeah, and like I said, if he's confident that putting it in Title 13 works, I'm totally fine with that.
Yeah, and I have questions about that, but it's really for him more so than.
Sure.
So, Joe.
I guess just the mention of Title 13 brought this to my mind. Would there be penalties associated with?
It's the way this is drafted, it's a trespass violation. So whatever penalties you can do for that.
Didn't we, not necessarily a question for you, Joe, didn't we wrestle with last year or two on a firearms bill about carrying in here?
In the Senate did.
Right.
And that's what ended up being just the hospitals. When it finally came over to here, it was hospitals only.
Right, and I believe it was pulled because you can't regulate in public buildings.
I can't recall exactly why that was.
Courts are firearms free. I mean, you have to.
Courts can do their own rules, and I think that we're firearms free in this building.
We are, and that's my limited understanding. It's under similar trespass violations by rule.
So we probably don't need to get deeply into that. We'll stick with just this
Sure.
bill right here. And All right, thank you. And we'll have Chris join us now, Chris Bradley. I do want to just flag, I did want Chris's input and also Allison's input on another possible amendment, which everybody has on their desk. It's also posted. I can give it to Chris, and it's online if Allison hasn't seen it yet. But last biennium, I don't remember exactly when it was, we did pass a bill that banned possession of firearms within hospital buildings. We did have an exception for law enforcement, but there's some other exceptions that we neglected to put in there and actually has been raised by another member. And this would add additional exceptions to that ban of firearms in hospitals, including security guards who are licensed, corrections officers, law enforcement officers from another state who are exercising legitimate law enforcement purposes, and Vermont National Guard who is on duty. These would be additional exceptions. So I'm just asking Chris to be able to comment on that if he can. And Allison as well. So Chris, thank you very much.
Thank you very much for your time.
Yeah, thank you, Jim.
Folded in here.
Yeah, not the most comfortable chair.
For the record, Chris Bradley, I'm the president and executive director of the Vermont Federation of Sportsmen's Clubs. As you are probably well aware, I typically have written testimony that I like to read from so I don't miss my points. I only saw language for the amendments actually yesterday. Although we were made aware that they were coming. To the bill at hand, as far as sections 4, 5, 6, and 7, which are the sections that predominantly have to do with firearms prior to the new amendment, I was prepared to not give testimony at all because 4 and 5 are existing federal law, as you know, straw purchases, as well as defacing serial numbers. Because we already operate under those laws at the federal level, I could make noises about why are we replicating state law with federal law. If the feds aren't doing their job, then that's what we're paying them to do. And if there's a problem there, maybe we should get our money's worth. But I understood, listening from law enforcement, that this was another tool in your toolbox. So we're prepared from the Federation perspective to say Section 4, Section 5, don't particularly like them because they're redundant, but there's no real issue. We already operate under those laws. Prohibited people, the Federation is about law and order. We don't want to see prohibited people with firearms. I do need to mention that word again, Bruin, because there is some unsettled things with Bruin as it applies to sections 4, 5, 6, and 7. For example, there was a determination made that under Bruin, having a gun with a serial number or not really made no difference. Just so you're aware, federal law says that you cannot receive a firearm without a serial number. And just to put this in perspective, serial numbers were only came into play in the United States in 1968. Prior to that, you did not have to have serial numbers, although most manufacturers, this is a matter of tracking their own product, had those serial numbers. So prior to 1968, it wasn't serial numbers. After 1968, there had to be. And so 4, 5, 6, and 7, you did not have to see my smiling face. I was just going to preserve your time. I have now met with Representative Harrison. We're looking for some sort of solution here. I am going to take a step back. As Representative Gosselin mentioned, I have served my town as a water and sewer commissioner, electric commissioner, numerous years as a lister. I served as grand juror, and I also served as a selectman. The selectman was a interesting position. And as Mr. Gosselin, Representative Gosselin alluded to, much like Mendon, we had a individual that was interesting. As the select board, because there were zoning violations, we had to take property from him to settle debt that he had accrued because of zoning violations that had built up. I am 6'9". I don't usually feel threatened by pretty much anybody, especially in Vermont. I can tell you, if you saw me in a select board meeting wearing a coat, which I usually didn't, it was because I was concealed carrying, expecting that gentleman to come in with a shotgun and settle a score with myself and my 4 other selectmen. I think you have town clerks handling money. I think there's a reason why municipal buildings and municipalities in general were set aside when it came to providing them laws. That's why we get very jumpy with 24 VSA 2295, or what I refer to as the Sportsman's Bill of Rights, because it sets in concrete certain things that municipalities can't touch. And as Representative Harrison alluded to, one of those things is carrying. But that is a two-edged sword, because if you're preventing your employees from carrying, you are preventing them from defending themselves in bad situations. I don't believe, well, I guess as I listen to Mr. Harrison, I'm very curious. We solved the problem in Northfield because we had our own Northfield Police Department. And when we felt that there was a problem, we asked for a police officer to be at the door, at the meeting, just monitoring things. And because we had a police department literally 2 minutes away from where we meet in our town offices, they were readily available. So I have some grave concerns about that. I do understand the need. As far as 24 VSA 2295 and the ability for a town to have a trespass law, I believe Mr. Harrison referenced it. Any business in the state of Vermont can legally put up a sign. It's the same thing that says no shirt, no shoes, no service. That can just as easily say no firearms. And that's a property rights issue. And from at least my non-legalese perspective, I believe that's perfectly legal. And a citizen then has an informed right to say, I'll either go there or not. Stepping back for a minute to the hospital bill, the hospitals had signs up, no weapons, no firearms. And this was prior to the hospital bill even being thought of or brought forward. And as it was brought forward, initially it was 3 things: hospitals, daycares, and government buildings. Well, we have to put government buildings, at least state government buildings, aside. GSA came in and said, we're in, this is in testimony, 13 VSA 3705, unlawful trespass is working fine for us. And in fact, we don't want our buildings in that hospital bill because we've already got this covered. We have it adequately, and it's all based on the unlawful trespass. Interestingly enough, the daycare people came in and said something, and these are for little kids. They were very insistent that they did not need this law. So it came down to just being hospitals. And frankly, I don't want to open a can of worms here, but I think nobody with a sense of propriety would walk into a hospital, just as an example, openly carrying a firearm. It's just, it wouldn't be done. I mean, yes, there's probably exigent circumstances. Someone was out hunting, somebody had a heart attack, you had to take them into the emergency room and you didn't realize you still had a firearm on your hip or something. But I specifically see a difference between open carrying and concealed carry. As you know, Vermont is a state where you can both open and concealed carry without a permit. And in fact, the shall issue nature of permitting is more and more taking place in the country, especially after the Bruin decision in New York. So the Supreme Court has said we not only have a right to defend ourselves in the home, We have a right to defend ourselves outside of the home. So we need to put some things around that, and that's now touched on the whole issue of sensitive places. And we know, for instance, that the island of Manhattan can be declared a sensitive place. However, Times Square on New Year's Eve probably could. So there's a lot of conjecture and unknowns. We are willing to work with Mr. Harrison. What we proposed was the beauty of the unlawful trespass statute is that it allows discretion by law enforcement. So law enforcement can come to wherever this is and say, excuse me, you've got a firearm on you. Do you know you shouldn't have that? Can you take that back out to your car, please? And you can either comply or not. If you fail to comply, then the police officer can incarcerate you, separate you from your weapon, put you in the cruiser, and cite you. So it allows for some discretion. At least that's what we thought in a hospital situation. You have to call law enforcement. Somebody has to call law enforcement to have law enforcement there. So, and by the way, that could have been anybody. That does not have to be the owner. That can be any agent or designated person. So a nurse could have called me. And one of the reasons we didn't like guns in hospitals bill, yes, we understand hospitals are very sensitive places. We understand there are bad things that happen in hospitals. There are people going in looking for drugs and very bad medical situations there. However, unless you're going to have security guards doing screening to say nobody's getting in here with a gun, then someone who has a habit carries a firearm concealed because they feel the need to defend themselves or their family or others, they are putting themselves at risk, in our opinion. So I guess, Chair Lalonde, we're concerned. Did the problem get solved with the institution of requiring appointments? I didn't hear at all, and I did hear Representative Oliver mention, this sounds like we couldn't have initiated an ERPO here. Is this guy really that close to threatening people that either it's disorderly conduct or something like that? I didn't hear at all that firearms were even referenced as a threat. Yet we've now gone to the point of saying, okay, well, he might do this. Well, he might do a lot. He might drive his car into the building. I'm not trying to be ridiculous here, but we have concerns concerning this. We'd prefer to see 24 VSA 2295, the whole Sportsman's Bill of Rights, somewhat left alone. We think it served and the reason for that is very simple, just so you know. Consider the Wayside restaurant that sits between Berlin and Montpelier. If we were allowed in this state to say Montpelier can make its laws for how you can handle a firearm, and Berlin was allowed to make its laws, and they could be disparate, depending on where you parked in the Wayside parking lot when you went in for lunch, you could not even know you're illegal. There, I can't store a gun in my car, but here I can, 10 feet away, I'm okay. So we wonder if this is extreme. I also have a question about whether it's really germane to the real core of this bill, which is a juvenile bill, and looking at juvenile crisis. But ideally, this is, we are working with Tucker, and we'll continue to work with him. Is there any questions for me? I really don't want to belabor this, but.
So, yeah, I guess the main point, I understand you're still opposed to the hospital bill. You haven't really commented on the exceptions, but you don't have to comment on that. That's fine. But so I understand that you don't like this to be certainly in Title 24 where it's proposed here. You might be okay if it's just worked within the trespass law in an appropriate manner.
The trespass gives a framework where we think there's a discretion can be applied by law enforcement. And frankly, we don't think we need to see this at all.
But if we made clear that, I'll see what Tucker and Jim Harrison and you have been working on. So
At least there's discretion. We lost discretion in the hospital bill. If a mother went in to pay her bill and she had a concealed carry in her pistol in her purse, and the person that she was paying the bill just happened to notice that she had a pistol, it's strict liability. There was no discretion involved. Previously, there was discretion with 3705, which was what was being used by the hospitals before. And I have signage, and there apparently wasn't. We believe that was statewide, that all hospitals had those signs. But again, I don't want to belabor this point. We were fine with S4 with the work we did in the Senate. So we didn't really see the need to take up any more of the committee's time. But this amendment is of concern.
fair enough. Yep. And it sounds like it's still in process and may not be ripe for putting in here anyway, but we'll see.
Perhaps next year would be a better time for it. Any other questions for me? Thank you so much. I really appreciate it.
Thank you for being here.
No, my pleasure. Thank you.
I've got one question. In section 6, around the person subject to final relief from abuse or stalking order, do you have any issues there with due process?
Bruin will be an issue here. I mean, we already know, for example, that somebody was under indictment previously, could not have a gun. That's been overturned by the Supreme Court. We know that in domestic violence situations where firearms have been confiscated ex parte, that's now in the crosshairs. That's in the, I think we could battle back and forth with the Supreme Court of New York. He took me to school. Thank you. So yes, there's some concerns. As far as we're concerned, they're not quite ripe yet with Bruin, but they will be. So at this point, we just did not feel it was, we understood the intent. And after listening to what was going on in Bennington, this is a real problem. I mean, this is a huge problem.
So you support the bill or you're just not opposing?
It's very difficult to support this bill because it's duplicating federal law, which is actually stronger than state law. I think it's more accurate. We want to oppose the bill.
Say again?
We will not oppose the bill. Any other questions for me?
It's good. Thank you very much.
No, I really appreciate it. Thank you very much, Chair.
Hey, Allison, and if you're still there with us. And actually, Allison, I see that you submitted written testimony, and given the time that we have, if we could rely on the written testimony for your comments on the underlying bill, and if you could just address, if you're able to, the two amendments that have or possible amendments that have come up today, if that works.
Yeah, I did a cursory review of them. Absolutely no objection to either, especially the hospital's one, with anything that's going to make that more workable for you all. That all makes sense. So I might look deeper to make sure I don't see any technical things that might be addressed, but yeah, after a cursory look, no objection at all to that.
Okay. And if we have any particular questions, and you commented on the sections 5 through 7 in your written testimony, I believe. We haven't had a lot of questions on those particular provisions yet, but if people can think about whether there's any specific questions. But I will ask you one other question, though. As far as what's the latest and greatest on the legal front as far as sensitive places? And I guess this would go to whether we could give municipalities the authority to have restrictions in their buildings.
Well, that shouldn't be a problem. There are several states that allow municipalities to have their own restrictions on sale and regulation, that don't have a preemption law like Vermont has. And there's various flavors of preemption law. So having this amount of authority, I don't see any issue with that. There's been some litigation in sensitive spaces, and I can check with my litigation team to make sure I'm reporting everything accurately. But if you look at the Bruin decision, that's something that's listed explicitly as something that's allowed, is to carve out certain sensitive spaces. Places that are central to democracy is one that is described in the bill as a place that you might not want to have carry of any firearms at all. And so a lot of states have looked to strengthening their list of places where guns are not allowed to be carried. So this is a pretty modest provision, so I don't see any litigation concerns there.
Great. I think we're good. And I think, like I say, you covered the other bases in your written testimony. I suggest everybody take a look at that. But I had read it and nothing jumped out at me as needing further questions on that. So
Right. Feel free to email anytime. Happy to answer any questions that come up.
Right.
It's great to
Thank
be
you
here.
very much.
You all.
Thank you. Appreciate your time. So Rebecca Turner, if you could join us. And I understand that Marshall punted sections 2 through 7 to you or something like that.
Oh, that's fine. I was testifying on those sections in the Senate Judiciary. For the record, Rebecca Turner from the Defender General's office, sharing our continued general but specific to particular sections, and that's for the DG's opposition to this bill. You heard from Marshall yesterday. You're hearing from me today. This is not, as you know, typical of our office, coming in with two different witnesses from the same office to talk about one single bill. I think that's a direct reflection by what we already know. I mean, I see I'm one of the last witnesses you're hearing from, but how massive this is. This is absolutely massive. And I think if there is one takeaway point from this, is that this is too much, too fast. Too much, too fast. And I will be speaking primarily on how that teases out in the Second Amendment context, given the litigation that is unfolding by the week. In fact, I just heard the amendments proposed on sensitive places. I haven't had a chance to look at that closely, but hearing from the last witness, I can add that, yes, I do know that there is ongoing litigation on the question of sensitive places post-Bruin in the Second Circuit active. Several cases, and they're at the injunctive level, but it's going up and down. So again, waiting a few months could resolve that question. That's just the sensitive places. But let me start in and be methodical about going through this bill. Let me start with Section 2. This is page 6. Let's see. So this is not raising Second Amendment issues here. I want to touch down what I understand has been some questions raised here, which is the meaning of recklessness as used in here. And I want to share from the appellate perspective, again, working with these definitions heavily all the time. It's commonplace. Recklessly is used and appears in code. What's significant is that Title 13, Title 23, the motor vehicle codes, Title 18 with the drug offenses, at no point has the legislature defined recklessly. And that doesn't mean it doesn't have a definition. There's absolutely a clear definition, narrower than the one that this definition captures here. So that's significant. This broadens it, meaning that it makes it easier for more people to be captured by this crime, this felony crime that this is now being proposed to be. So just know that that's a significant departure how the legislature is treated using the word recklessly any other place in the criminal code, never defining it. Know that this definition, which is on page 7, lines 14, 15, does not track with the current definition of it. Vermont Supreme Court has been clear and repeatedly clear. State v. Brooke is one case that 1995, 163 VT 245, where the Supreme Court lays it out and then also explicitly adopts the model penal code's definition of recklessly. Again, more narrow than what's captured here. And for want of enough time to go into it, 1415, lines 1415 captures just maybe a third of that definition.
Can you tell me again, it was a 1995 Vermont 163? Just want to make sure
163 VT 245.
163 VT.
245.
Thank you.
1995, State v. Brooks, and then there's the complete quote of the model penal code, which has been adopted.
Okay, good.
So the last thing, it would absolutely, inconvenient is a simple way of putting it, to have this one definition track with how it's otherwise been understood, how the case law has developed. So I want to point that out.
So as a proceed.
Yeah, so, in that sub-E section, recklessly means consciously disregarding a substantial and unjustifiable risk.
Yeah.
And so in State v. Brooks, they quote the model penal code, person acts recklessly with respect to a material element of an offense when he consciously disregards a substantial and unjustifiable risk that the material element exists or will result from his conduct. Risk must be such a nature and degree that, concerning the nature and purpose of the actor's conduct and the circumstances known to him, its disregard involves gross deviation from the standard of conduct that a law-abiding person would observe in the actor's situation. So if this was to be put in the statute, you'd want that entire paragraph I just read in there?
First, it should not be broadened to include recklessly. Recklessly changes the mens rea fundamentally. It's no longer a subjective intent, right? It's an objective standard. So one should have known effectively, right? But there's a specific definition. So reckless, so it should not be. It should not be expanded upon. You've already heard about the problems with this statute, the racial disparities issues, the enforcement issues, which allows for a lot of arbitrary enforcement, selective enforcement entering in. Recklessly is one way of how that happens. You're broadening the net and the culpability. So Defender General's position is drop recklessly completely, keep it knowingly. I think that it expands and making it easier who can be charged for this.
But if it was to be kept in there, you would want that entire paragraph.
No, I think next, if recklessly is to be kept, it should track with how recklessly is referenced every other place in Title 15 and 23. So not define it. Just know that is the definition, and it should track. But again, our position is there should not be any downgrading, expansion of this offense. And I also point to the fact that here the proposal is increasing to 5 years, right? So when it's a due process problem, and I've talked about this before, when you elevate the penalty, turning it from misdemeanor to a felony, but a 5-year felony, lowering the criminal culpability, right? You are entering territory that is open to challenge to due process violations. Again, because it is contrary to general criminal law, that your culpability, your mental state should match the penalty that attends. So the higher you increase increase the penalty, 5 years imprisonment, there should be at least a knowingly mens rea, subjective intent. You should know that what you're doing have that criminal intent involved. So that is section.
I want to follow up on that. It's a question I've asked everyone. I know your position on this, but can you think of what it would mean to recklessly violate the statute as opposed to, I feel like every time I've asked this question, people have told me like, well, they knew, or they got this notice, or people talked about it with them. And I'm like, well, that's knowing. And do you have any idea what a reckless?
I think that your questions and the answers you've gotten answers the point that it is absolutely an offense that you acquire knowing mens rea, right? And no one, and so that opens up a notice issue, notice due process problem. How does one know that you're subject to this kind of 5-year felony liabilities recklessly when not even the prosecutors or law enforcement can identify it other than scenarios that fit within a subjective knowing intent? So that's section 2. Section 3, same concerns. That is knowingly or recklessly permitting human trafficking. Again, lines 11, 12 on page 8, using that definition that doesn't occur anywhere in the code, recklessly. So again, opposing this statute, generally, the downgrading expanding for recklessly, that should be dropped as well. Let me turn to section 4, defacing firearm serial numbers. Section 4, 5, 6, 7, which do not just concern Second Amendment problems, but also Vermont constitutional problems, and that's specific to the bail. And let me focus on the bail pieces of that. So section 4, section 5, and section 7 all contain language making it explicit that the conduct constituting this offense may be considered a violent act for purposes of our eligibility for hold without bail. You've heard that was changed from shall to may, and this position that will cover any Vermont constitutional concerns. I am here to share with you that I do not think that makes it constitutionally compliant. And just changing the shall to may, presumably giving the judge the discretion to ask for it or not, still fundamentally has to comply with section 40, chapter 2 of the Vermont Constitution. And I know that's been discussed always. And the plain text of section 40 requires that for the carve-out exceptions to the presumption right to release, these accepted situations where someone can be held without bail, pre-conviction, for 7553A offenses requires not just an element of the crime being an act of violence, has to be also against another person. Element involving an act of violence against another person. So the discussion as to, oh, well, it depends on the facts, you don't even get there. You look at the essential elements of these crimes, you don't have an act of violence against another person necessarily involved. Why invite the judge to do something that he or she is unconstitutionally supposed to do? And so that doesn't belong anywhere in here. Always, if it's how this legislature has treated offenses, whether or not they qualify under 7553, that's being done now. It's done now. The prosecutor asks for it, if it's eligible. If this offense qualifies, then the court can so order. Always. So this language doesn't change current law in terms of whether or not the offense qualifies for hold without or not. It just now actually establishes and is contrary to what the Vermont Constitution allows. Again. Yeah.
Oh, sorry. Go ahead, Kate.
I have a question with that, because I do think the change from shall to may is important. One, like the shall makes it clear, which I'm not saying I agree with that either, but the may, I feel like it's another example of how I feel like it opens up the door for more disparities, because it has the potential of, well, maybe I'll give you this, I won't give you that, and that implicit bias piece of it. So I just think that's maybe wasn't thought out when it got changed to may, that opens up that other door to that as well. So I appreciate you pointing that out.
And I appreciate you bringing up what I think is a theme that this committee has heard today, which is how does this bill, which doesn't explicitly necessarily address race, implicate racial disparities concerns? And again, this is another piece of news. Exactly right. May, anytime there is an allowance of discretion to enter into the equation, absolutely. The implicit, explicit biases, it's a way to come in. So I think that applies every time that there is language here identifying that 7553A, this offense may qualify. So I saw that as occurring in sections 4, 5, and 7. And again, so those entire lines, those subsections should be struck. It doesn't change current law. 7553A applies, it applies. You don't want this to be directly contrary to the plain text of the Vermont Constitution. As to the Second Amendment concerns, let me go through it a little more details. You've heard me come in on other bills to talk about Bruin, and so I'm not going to talk about the test. But the test is straightforward and clear. Are the arms covered by Second Amendment? And if so, can the state overcome the presumption of unconstitutionality by establishing a historical tradition of regulating the content? Now, I wanted to walk you through that because these sections, straw purchasing on section 5, section 4, defacing serial numbers, section 6, creating a new crime relating to fugitives fleeing from justice, section 7, while committing a felony, or new firearms offenses, tracking current federal crimes under 18 USC 922. Post Bruin, which is almost now a year out, June, came out last year, has been that those subsections of under section 922 have been under attack, litigated, and there have been decisions from the federal district court level and the appellate courts handful striking down the 922 subsections and including these ones sent out. So I just wanted to share that you should know going into this, it's that there have been federal courts already striking this down as facially unconstitutional under Bruin. And I can share the names of those cases. I know what the concern has been, that you've heard witness testimony saying, well, it's actually unsettled law. And we can't wait, we need to go forward. Well, my testimony here today, again, coming to you as someone who litigates constitutional issues and studies the Constitution, it is incredible the speed, the rapid speed that these decisions are coming out. And so I just again would urge this committee to just take time, put this on a study committee group. Let it hold. I was on a call with another litigator in a different part of the country yesterday, and I happened to learn, because I'm not tracking this, there's a pending case being argued at the Second Circuit involving one of these subsections relating to Section 7, being argued at the Second Circuit first week of May, and so there could be a decision in a few weeks from now. Again, the position of how I read Bruin, and I've read these decisions in the proposed language, this is they're unconstitutional on their face. Any questions on this?
Questions?
Please send those sites along.
I do. Yeah, I will.
Other questions? I think we're well versed in Bruin by this point, and just have.
Yeah, and I think that's fair. I get that. I feel like I've been here. The differences in this bill, there are so many decisions already from federal courts striking these sections down. Whereas in other bills where I've talked to you about Bruin, it's been, drawing by analogy. Here is your territory of where we are having the landscape of litigation overturning these laws at the federal level.
All right. Thank you so much for being here on such short notice as well. We appreciate your flexibility. It's important to hear from you on those sections. Definitely, I take some of your concerns to heart, definitely. Still not agreeing with you on the Bruin one, but the other parts, I as far as the hold without bail, I'm very concerned about those. Very concerned about those. I have one question. Oh, you had a question? Yeah.
Where's that music coming from?
Yeah, it's Wayne LaRouche. Yeah, he's playing next door. Yeah, he brings in his banjo.
I didn't know.